to enforce something as important as the federal securities laws. Wilco means to us that the court said, you know, these federal securities laws, section 10b, I think it was 12.2 that was issued in Wilco, the exercise of judicial discretion to fairly assure the effectiveness of the federal securities laws. That's what Wilco was all about. Then, of course, you know, Shearson comes along, 1987, one of our practitioners in this business. Matter of fact, we know the lawyer who argued on behalf of Shearson in the Shearson versus McMahon case. And there you look at the court's reasoning. The court says, you know what? A lot has changed since 1953. It's okay to have arbitrators decide these issues and these cases because, after all, now we have an NASD code of procedure. You know, the major thing behind the court's reasoning is that now we have the SEC. The SEC has oversight authority with respect to the NASD. The NASD has promulgated all these little rules, you know, rules regarding discovery, rules regarding you know, substantive issues and procedural issues. So therefore, it's okay to have arbitration because the NASD code of procedure you know, puts some due process into the equation. What we really have is still the old folklore arbitrations. Now, it's interesting because back in the old days, you wouldn't know this, but the people who were really behind having arbitration agreements in customer cases was the industry. The industry wanted to have arbitration. What is the industry trying to avoid? We've all heard about the runaway juries, the juries that award, you know, huge amounts of punitive damages, the juries that were uncontrollable as finders of fact, and therefore we need to have a panel of arbitrators, at least one person from the industry. And it was the industry that was the big supporter of arbitration. Well, you know, nowadays that's all changed. It's not the industry that wants to have arbitration. It's the customer. The industry doesn't want to have arbitration. Why? In court, you folks know from your civil procedure classes that we have the Private Securities Litigation Reform Act. So if someone files a complaint sounding of securities fraud, you have to be able to plead scienter. There's going to be a stay of discovery until the motion to dismiss, one chance to have the case dismissed. There's going to be a lot of money in deposition practice being spent. There's going to be motions for summary judgment. Basically, the courts are going to serve as a gatekeeper to prevent you from getting in front of that jury, because there's going to be all these obstacles where at any point in time your case can be dismissed. So if you have a case, we'll talk about this later, in selling away, for example, that case might be dismissed as a matter of law. Whereas in arbitration, the customer has a better shot of getting their final day in court, so to speak, before an arbitration panel. So now we see, I think part of your reading materials, are cases where the industry has sought to adjoin arbitration because they say, hey, this person over here is not even our customer. Yeah, they're a member of the public, but they're not our customer. There's no duty to arbitrate. We want this case heard in federal court because we think we can get it blown out on a motion to dismiss. We think we can get blown out on a motion for summary judgment. This claim is legally insufficient, and all the legal niceties that attach to a civil litigation, the industry now wants to have heard in court as opposed to arbitration. Arbitration has become so commonplace because courts, as we saw in the Blasher case, will order arbitration even if there's not a written agreement. You folks have all read that AT&T case where the courts say, oh, well, gee, you have to have arbitration can only be compelled when there's a written agreement signed by the parties. That's nonsense. The court in Blasher actually said that it's so commonplace, the agreements to arbitrate are so commonplace in agreements that we're going to enforce them even absent a written agreement to arbitrate, a signed agreement to arbitrate. And what's really going on here is that the courts just don't want any part of this. I mean, you look at the statistics in your casebook. I think it was in 2002 or 2003, there were close to 10,000 cases that were filed before NASD dispute resolution. That's 10,000 less cases that the federal courts have on their dockets.